Yes.
Okay, okay. So I think you already know our topic of today's discussion because I have advanced inform in the group. Okay. Actually, I have received some of the topic from the group that you said that you need more discussion on this topic. That's why I thought I will start discussing today on this topic. Okay. Just 1 minute. Okay. So, dear student, so today's topic is what? Judicial activism, right? Although I have discussed this entire topic very detailed in my class, okay, but today, even if you missed in my class in the college, okay, in today's class, I will actually give you a short summary of what is judicial activism means and when it was started in the worldwide and when it was started in India, and then uh, why it is important and what are the justification actually in favor of this judicial activism. We'll try to understand. Yeah. So let's start. So see, this concept of judicial activism actually had not developed in India. Okay, this concept of judicial activism initially developed in where? In the United States of America. Okay, and this term, the judicial activism, was actually first coined by an American historian and educator. Okay, his name was Arthur Schlesinger. Okay, Junior Arthur Schlesinger. Okay, in the year around 1947. This is the time when this judicial activism was actually introduced and developed in the United States of America. But in case of India, okay, this term you can say that introduced in India around mid 1970 or 73, 75, around this is the time 1970. Okay, this is the time when this the judicial activism was actually introduced in India by a group of actually eminent jurists and judges. I'm not going to use today any PowerPoint. Okay, so please listen carefully. And during my class, or even if you have any question, you ask me, or otherwise, I'll give you the time also at the end of my class for asking the question. Okay. So see, this in India, this judicial activism, you can say that started or introduced in mid 1970s by a group of eminent jurists or judges. Okay, they are like very famous judges. Okay, like Justice P.N. Bhagavati. Okay, and then B.R. Krishna Iyer, D.A. Desai, O. Chinappa Reddy. So these are actually a few eminent jurists, okay, or judges who laid the foundation of judicial activism in the India. Okay. Now we understood when it was started in the global level, when it came into India. Now what is judicial activism means? Okay, we should understand, right? So let's try to understand in short what is judicial activism means. See, judicial activism we can refer as a proactive rule by the judiciary for the protection of rights of the citizen and for the promotion of the justice in the society. So, I mean, in short, it is a role actually played by the judges or the judiciary for what? For the protection of the rights of the citizen and also for what? Promotion of the justice in the society. Now, in there may be so many situations, okay, where the existing laws are not enough to deliver justice, okay, in any particular incident. This is the time when the judges actually can allow their personal views, okay, to provide justice. Okay, so this is that's how we call it a proactive rule. Okay, so this is what we call judicial activism. Now, in order to understand this, okay, more clearly, I think we have to go back to the ancient time when monarchical system actually used to exist. Okay, There I'll give some example also, then it will be more clear. Okay. Now, why judicial activism is also important, you will understand. Okay. Let me take you all to the monarchical phase. Okay. In the ancient time, you all know that monarchical actually form of government was very popular, right? Yes or no? Can you hear me?
Yes, sir.
Yeah. In the ancient time, monarchical form of government was very popular. Okay. And one of the very important feature of monarchical form of government is what? The king himself is the supreme. I mean, he is in one man army. All the power, okay, is concentrated in the hand of king only. That is, I mean, he is the head of the executive, right? And he is the head of the legislature, means he makes rules, right? Implement these rules, and he also actually head of the judicial system. Even though judges were there in the monarchical form of government also, but ultimate authority was in the hand of the king. So in ancient time, king was one man army. He had everything. So all the power was concentrated in the hand of only king. But it is not a good system. Okay, because uh, later we have evolved, and many thinker actually also back then many thinker philosophers they realized that if all power is concentrated in the hand of very few, then what will happen? Those people who are ruled, means common people, subjects. Okay, they they are they have to suffer a lot if their ruler is not good enough, right? That is why some of the philosophers they actually started thinking about the alternatives. And from the result of this situation, okay, these types of thinking, some of the philosophers, like for example, one of them is very famous. I think you heard about his name also, Montesquieu. Have you heard about his name, Montesquieu? A French philosopher. He actually came up with the very important doctrine of separation of power. Okay, and this doctrine of separation of power, what says? It says that okay, the power should be divided among the different organ of the government instead of concentration of power in the hand of a single person. Okay, now, based on this doctrine of separation of power, okay, many modern democratic countries, okay, they divided what? First of all, they abolished the already the monarchical system, and they established what? Democratic country. And in the democratic country, they divided the power between the three organs of the government as per the theory of separation of power. Okay, let me explain a little more details. Separation of power is a theory given by the Montesquieu. He was a French philosopher. Okay, in the year 1948 and 50. Why to date? In 1948, this theory was published in the French, and 1950 it was published in English. Okay, so what happened? As per this theory, the power should be divided between the three organs of the government, and you all know what are the three organs, right? Like legislature, executive, and judiciary. Legislature duties to what? Framing the laws, policies, right? Executive duties to what? To implement these rules and regulation, right? And the judicial duties to what? To interpret the law and to dispense the justice, right? So, as per this theory, okay, the power should be divided between among these three organs of the government. Okay, and by following this theory, okay, some of the democratic countries they actually adopted this principle, and they actually applied in their country also. And one of the classic example of this situation is America, because America actually adopted this concept of separation of power. Okay, so in their country, the executive, legislature, okay, and judiciary, their duty is separated by the constitution, okay, and as per their respective jurisdiction, they perform their duties. Okay. In case of India also, okay, we actually, even though we have this three organ of the government, legislature, executive, and judiciary, but in India we do not have strict separation of power. Okay. Now, why I am telling all this theory, you will understand, okay, after 1 or 2 minutes, okay, because it's very important for understanding judicial activism. Now, why we do not, even though we have three different organs with different types of functions, but still we cannot call it a separation of power. Because why? In fact, we have some degree separation of function, okay, but not complete separation of power. Means in our India, the same person who is an MP can become the minister. Minister is a part of what? Executive, and MLA is a part of legislation, right? Clear, na? So our actually in our India, we do not follow the strict separation of power. We follow the separation of functions. And when I'm saying separation of functions, it means here is some flexibility is there. Okay, judiciary, legislature, and executive, they can intervene in each other function. Okay, to some extent, it's flexible. Clear? Now, even though our constitution is a written constitution, okay, and it defined the responsibility of the respective organ of the government, okay. But sometimes what happens, okay, if all the three organs, that is legislature, executive, and judiciary, okay, they strictly follow their jurisdiction, okay, then it sometimes becomes it's very difficult to provide justice. Okay, especially when it comes to judiciary, okay, because judiciary needs to work, it needs to function as per the established law, right? Based on the law, they will judge whether any action is correct or wrong, right? Now you just imagine there is a situation where there is there is a situation where in order to deal with this situation there is no existing law. Then how the judiciary will dispense justice? Because see, main responsibility is to what? Judiciary responsibility is to what? To give justice. Okay. Now if suppose now I think John is there, right? Now John actually approached the court because he faced any problem in a specific situation where there is no existing rules or regulation applicable, right? In this situation, judges cannot actually give judgment, okay, based on the laws, because law doesn't exist on this area. So, and judge also cannot say, okay, you are facing problem, so I don't care. There is no rules. Judge cannot say, right? Just duty is to what? To dispense justice, to give justice, right? So how they will give justice? That is why judicial activism is very important. To certain degree of discretionary power is there in the hand of the judiciary, okay, through which by using it, okay, judges can dispense justice. Now you understood. When there is a legislative vacuum, means there is no existing law which can govern any specific situation, then judges can allow their personal view, okay, so that judges can give justice to the aggrieved person or to the affected person. Let me give you two examples. In the year 1997, can you hear me clearly?
Yes, sir.
Yes, sir.
Am I going very fast, or is it okay the way I am speaking?
No, sir, it's okay.
Okay, please listen carefully. Now, in the year 1997, you know what happened? I'm giving two examples. I will give two examples, okay, so that you understand. Number one is that it's very important case actually. That case name is actually called Vishaka case. Vishaka case. Now, in 1997, you know what happened? In Rajasthan, a female, her name was Banwari Devi. Banwari Devi. She used to work as a social. She used to work as a social worker. Okay, in a rural areas. Okay, and her rule was to actually to generate awareness among the people against the child marriage. Okay, in the Rajasthan rural areas, and the area where she worked, okay, the people was very orthodox, you can say that orthodox attitude, okay, and they used to follow the social customs, and they actually do not want to actually avoid these customs, and one of such custom was that like child marriage. It was prevalent there, right? And since Banwari Devi's response is to what? To generate awareness against the what? Child marriage, right? So there was actually one Thakur family, okay. His name is I think something Rajendra or something. Okay, in short, you just remember one Thakur family, okay. Their daughter actually they wanted to give Mary before completion of the 2 years. I think 1 year. I think she was at infant stage. That time they decided to give Mary. Can you imagine? Okay, So she actually tried to stop it, okay, even though she failed because they were very powerful people, right? So finally marriage happened, everything done, marriage happened, right? Okay, but since she tried to actually stop this marriage, okay, as a result, they the people of this that village actually they started social boycott. Social boycott means the other people of this village, okay, not allowed Banwari Devi to come their home in the social programs, gatherings, okay. So people started, social boycott, okay, because she challenged the established customs, okay, which was the evil customs, right? And the person of, the family who were involved in this child marriage, okay, they didn't stop there also, okay. They actually, after a few days, they actually gang raped that Banwari Devi, okay. And after that, what happened, even when she approached to the court for getting justice, okay, and she examined herself so that she can prove to the court, you won't believe that the people were so powerful that, okay, she failed to prove in the court this case, okay. As a result, all those people actually, who initially detained for this case, they actually came out from the jail also. After that, some of the NGO of the Rajasthan, okay, what they did, they actually, one of the, I think, NGO name was, I think, Vishaka, and Vishaka, actually, 3 or 4 NGO, they came together and they filed a petition in the Supreme Court, okay. Now, when they filed Supreme Court, okay, in the year 1997, Supreme Court came up with a judgment, okay. Now, see, now situation back then in 1990, before 1990, actually, you can say that 6 or 7, okay, there was no existing rule or law, okay, which can give justice to any female or woman, okay, if she is facing sexual harassment in any workplace. There was no rules or regulation. In fact, you would be, surprised to know that only after 2013, okay, our parliament actually, enacted a law for dealing with the sexual harassment related issues in the workplace for the women. So back then there was no existing law through which they can actually punish the people who were involved in this case, gang rape and all, right? So as a result, now when this the Banwari Devi, okay, approached to the different NGO, and when NGO, submitted a petition to the Supreme Court, okay, that time now Supreme Court cannot say, I will not give justice because there is no existing law through which we can I can give you the judgment, because Supreme Court duty is to what? Giving the justice, right? Now people came. Now since there is no existing law which govern this situation, it doesn't mean Supreme Court will say that no, I cannot give justice, right? If Supreme Court say, then it will be avoiding its responsibility, right? That is why Supreme Court in the year 1997 came up with a very famous guideline called Vishaka Guidelines. Okay, in these guidelines, okay, Supreme Court mentioned, okay, in fact, Supreme Court instructed also the state to actually frame a law in this regard. Okay, and later, in the year 2013, based on the guidelines established by the Supreme Court of India, okay, the Parliament of India enacted a law called Protection of Women Against Sexual Harassment at Workplace in 2013. So see, before 2013 there was legislative vacuum. There was no existing law through which a judgment can be delivered, right? In this type of situation, okay, judge cannot actually stay, remain, silent, right? They have to deliver justice, right? That is why they can actually allow their personal view and can give justice. And this is actually one example of judicial activism. Is this clear? This example? Can you hear me?
Yes, sir.
So here what happened, in short, when incident happened, okay, that time there was no existing law through which that female can get justice, right? So that is why initially she faced a lot of problem. But later, when she got support from the different NGOs, and NGO when filed a petition in the Supreme Court, then Supreme Court actually came forward and played a proactive role and delivered a judgment, okay, that even though there is no existing law, okay, still they actually taken the step and it came up with a broad guidelines, okay, not for giving the justice to the Vishaka, Banwara Devi, to the all women, maybe female in different places of this country, okay, females are facing the sexual harassment issue in the workplace, okay. So for dealing with all this situation, okay, actually, they provided, Supreme Court provided guidelines, and based on these guidelines, finally the Parliament of India enacted a law on this regard, and which was finally became an act in 2013. And that law name is what I said, no, Protection of Women Against the Sexual Harassment at the Workplace. Okay. Now another example, okay, it is an example of legislative backup. Means there is no existing law which can govern this situation. Okay. Legal gap, in short. Another case is that few years back, I think 2 years back only, okay, Supreme Court came up with a direction that, okay, there should be a firecracker ban in the Diwali, right? Now, it is actually, is it the responsibility of the Supreme Court to declare firecracker ban on all? No, actually. Why? Because issuing order or issuing order, okay, for the public is a responsibility of the executive branch, ministry. Okay, it's not the duty of the Supreme Court. Okay, but the problem is that even though Parliament actually enacted so many laws regarding the environment and pollution and all, okay, but not in a single law it is mentioned that, okay, firecracker should be banned because it is creating air pollution. So as a result, I think 2 years back it was published in the Hindu newspaper also that, okay, Supreme Court actually given a directive that, okay, not all, but those firecrackers, okay, who which are actually creating too much pollution, okay, they should be banned. Okay, so see here also Supreme Court played a proactive role. Okay, clear now? In order to what? In order to provide justice, right? Because delivering justice is the main duty of the court. Okay, now if there is no law, it doesn't mean they will not provide justice. They have to provide justice. That's why actually it is justified, okay, that they should have the judicial activism power. Okay, is this clear as of now? As of now, is it clear?
Yes, sir.
Okay. Now see, in India, this judicial activism actually can be in different form also, and one of the very popular form you should know about it. Okay, then I will finish. Okay, and one of the very important form of judicial activism is called PIL. PIL means what? Public interest litigation. Now, what is public interest litigation means? I think every one of you know, but still, when a group of people's actually interest is getting violated or rights are getting violated by any of the executive orders or the legislative orders or not legislative orders, legislative laws, okay, or rules and regulation, then affected person or on behalf of that person, any person can approach to the court and can file a PIL, public interest litigation, and then Supreme Court can give justice also on this, can judgment on this regard. Okay, so this is one form of actually judicial activism here, and also actually it is always not necessary that people have to actually file case, then court will give judgment. No, it's not that. What I'm saying, judicial activism means what? Judges also having what? Suo motu power. Now, what is suo motu power means? Judges can take own initiative. Okay. It's not that they will just silently wait for case to come and then they will come up. They will deliver justice. No. In this regard, they also can take suo motu initiative, self initiative. Okay, and then can give a directive to the state. Okay, to the executive and also to the legislature also. But sometimes actually it's become very difficult to demarcate, okay, between the function of the judiciary and the executive and legislature. Okay, because when judges actually try to use, because there is a possibility that judges also can misuse the judicial activism. They can interfere too much in the sphere of executive and the legislature. That is why actually it is very important to demarcate. But in our constitution, okay, it is not clearly demarcated at what extent, okay, we are flexible. In one hand, we are not rigid. We do not follow the strict separation of power. Okay, as I said, strict separation of power is there where in the USA. Our system is very flexible. But at what extent it is flexible? At what extent judiciary can intervene in the executive and legislative matters? It was not clearly defined. That is why in 2007, what happened? Supreme Court, said that okay. Actually, Supreme Court, made an observation and said that okay, that judiciary also should follow judiciary actually should not actually unnecessarily intervene in the executive and legislative matters, because judges are not expert in the administrative and legislative matters. Okay, and both have the right, and all the three organs, okay, they have the right to exercise their power within their respective jurisdiction. Okay, that is why each and every organ actually should actually use their power in a self-restricted manner. They should determine and define their own limits. Clear? So that is in short judicial activism. Okay. Now floor is open for all of your question. I mean, if you have any question, you can ask me on this topic. Any question? I'm giving too much time. I mean, at least approximately 15 minutes you can take, okay, for the discussion. You ask any question if you have on this topic. If you don't understand, I will repeat again also, but not after today's class. Please tell me if you have any question. Cyprian, any question on this topic?
Sir, if it comes in the exam, what shall we write? Only very few details we have on this. So if it comes for 10 mark, what shall we write?
See, when you should be a little bit smart, okay? When the question will come, they are not going to ask you, what is judicial activism for the 10 marks. Obviously, they will be asking about, what is the what is judicial activism? They might ask. Then they might ask, okay, what is the justification, in favor of this, judicial activism? And they might also ask question like, give, two statement, argue against in favor of the judicial activism, right? Clear, na?
Yes, sir.
So
what about function?
Activism, and then you also should know about some of the argument against and favor of the judicial activism. Okay.
Yes, sir.
And then you also should, in the conclusion, you should also analyze whether it is good or bad, because if judiciary actually unnecessarily intervene in the executive matters and legislative matters, then it is also not good for a democratic country, right? So you should also give your own views in the conclusion part, right? So it's not necessary that for the 10 marks you have to write 5 or 6 pages, okay? If you write properly within 3 pages, it is more than enough for 10 marks. Okay?
Okay, sir.
And it is also possibility that they might ask you what is judicial activism only, and they might add to some other part from other question. And also they might ask you, okay, to differentiate between the judicial activism and judicial review, judicial activism and judicial restraint. If you do not understand anything, please ask me now. I'm here. Judicial review, you understand now? Difference between judicial review and judicial activism?
Yes, sir, I know.
Okay. Anyone else? Any question? Any question on this topic? John? Snigdha, any question? Vincent?
No, sir, no question.
Ranzila, Megastri, Nisha? No? Okay. Since there is no question, actually today I decided, okay, I'll summarize the entire topic, then I will give you the gist, okay, what is judicial activism, and in short, some of the example, and when it was started in India. So my actually plan was to give a short summary. So I have given. So now, if you have any question, you can ask me. Because we do not have more time. Because next day I'll take another topic. Okay, I'll start another topic because you have sent some topic, I think, right? So I have to discuss this. I'll discuss because your exam was very near. Anyway, so that's it for today. Since no questions, so I am signing off here. Bye bye.
Thank you, sir, and good night.
Yeah, good night.
Thank you, sir.
Bye bye.